Today, on this World IP Day, we gather to celebrate innovators and creators worldwide. Hello, and welcome to this web talk on the changing landscape of IP law firms navigating the digital era. My name is Santosh Vikram Singh, and I'm a partner at the Indian law firm Fox Mandal and Associates, and I'm based out of Bangalore. I'm joined by a panel of experts from various jurisdictions to discuss how the digital age is transforming IP law practice globally. These are not only the IP experts, but they are also a close friend of ours. To start with, we would like to discuss the recent developments and their impacts in your specific jurisdictions. So I would like you all to highlight some of the notable shifts in your countries, jurisdictions, regions, wherever you are from, over the last few years that have impacted the IP ecosystem. That includes the IP practitioners, the innovators, the companies, the IP owners, or anybody who's part of the ecosystem. These notable changes could be through legislative changes, administrative changes in the IP offices, IP courts, or general practice in the IP law firms or wherever you find them. And also mention the specific reasons for those changes if there are any. So we can start with the Peter first. Peter, would you like to go first?
Well, legal activities in the UK have been rather preoccupied in recent years with our departure from the European Union. And Birgit, you might be representing Europe, but you're really only representing the European Union here. We're still part of Europe. We haven't.
I'm sorry. I'm so sorry.
But we're definitely preoccupied with the effects of leaving the European Union, and the legal ramifications have been colossal. The amount of new legislation that's flowed from that, which hasn't made any substantive changes, but particularly even in the field of intellectual property, there is a phenomenal amount of new legislation to get our heads around, and we haven't got time. There's no bandwidth in the UK government to deal with important issues like AI, or not enough bandwidth. Nonetheless, our government has announced that it has an ambition to be a global artificial intelligence superpower. Quite what that's supposed to mean. Well, that's the sort of language that politicians deal with, isn't it? It sounds good and it means nothing. There's been a consultation. The Intellectual Property Office ran a consultation on behalf of the government, and it looked at issues to do with copyright and patents, but there is no new legislation yet. I think they're still contemplating what the effects of the consultation are, what people want.
Can we come to Europe, which is which has been a part of, or UK has been part of Europe? So
vice versa, in Europe, Brexit had an impact on us, so we got more work. Another major shift during the last years, there was really a lot of harmonization within Europe going on. So we are really coming closer. So now we have the European patent since 2023, which I think was a milestone. And on all the new legislation amendments on trademark law, on copyright law, on consumer protection law, on competition law, now the Green Deal directive. So everything is going to be harmonized. So really the legal systems within the European Union are really getting more similar. And there is not much space left to national law anymore. And also the jurisdiction is getting closer since the ECG jurisprudence and case law. So I think we're really getting more and more harmonized. Another big effect, I think, was GDPR. So I think we lawyers, we also had a duty of confidentiality and data protection, especially with valuable trademarks and trade secrets. was also always a big thing, but since GDPR, we have big penalties and it's more transparent, I think, and being compliant with GDPR is one of the big challenges. And in Austria, we have now overall online filing, so you can file anything with any court within Austria online, and also with the Austrian Patent Office. And that means I can work anywhere in the world at any time. And I think that was a really big step to more freedom.
Super. Dilek, over to you.
I am here. Yeah, I can report from Turkey, just really chronologically. The PTO is digital since 2015, and in 2016 we had the new personal data protection law, which came into force. In 2017, the new IP law came into force, which is very, very similar to the EU law. And these were really milestones which directly affected IP as well. In 2019, we had the pandemic all over the world, and I can say that the digitalization in Turkey is very ahead. When I see some colleagues from Europe, or especially Germany, is very, very slow with the digitalization, even if the engineers, the software engineers and the best people are there. So Turkey was really, really, really ahead of everything, and really being totally digital at the PTO for about 9 years already was really a significant thing. And we in Turkey, I can really speak, I think, for all colleagues in Turkey as well, that we were always ahead in such things. In 2024, the new cancellation actions in Turkey came into force, which are now not regulated by courts, and it's a totally administrative procedure before the PTO. Turkey had really nearly each year a significant change, and I really can say from our PTO that we are really ahead, that the laws and regulations are clear, and we are very fast in everything. And then I just remember metaverse and NFTs were a really high topic until last year. And I think it is over a little bit. So I have the feeling after artificial intelligence that the topic metaverse and NFTs are a little bit done by side. So I think it was not a hype topic.
Ron, what has been your observation for the past few years? What are the changes Israel have seen?
Well, I have quite a few. Well, to start with, as you all know, Israel is in a state of war since October 7th, 2023. This war, officially known as the Iron Swords War, is is also known as the October 7th War. And we suffer great human loss, and the war affects everything and everybody in our lives, law firms included. Just one example, we suffer from an extreme shortage of judges in Israel, and there hardly have been any nominations in recent years. So this is one effect of the October 7th war. I will get back to it when we discuss ADR, which is one of the solutions to this problem. I decided my two items of choice are two judgments, case law, which I think they are very important. Stop me if I'm too long, because these are very complex cases, especially the first one, and you may be well aware of it because it's very well known. It's the Sanofi case. This is undoubtedly a groundbreaking, and I would even dare to say revolutionary judgment of the district court, who was upheld twice by the Supreme Court. So it's in the terms of Israeli system, it's irreversible now. It's revolutionary because the unjust enrichment law has never been used in such circumstances, and well, I would say that it has a far-reaching impact on any matter where a regulator is cheated or fraudulently led to award some rights. And I think that it is very important in the sense of it imposes very different duties on patent owners, and including on patent attorneys who draft the patents. It's completely.
Wonderful.
I think
just a follow-up a question, Ron. Here, generally, what happens in these kind of cases where there's a setback for the companies, they start lobbying, at various levels. Have you seen the companies, they're lobbying and then trying to put pressure on the government or something to change the rule and make the system more friendly?
Well, this always happens, and this is not always done openly. So I cannot really, and I'm not one of the attorneys who represent these companies. So this would be confidential inside information. But I'm sure that, well, I'm not sure, but I assume that this could be so.
Perfect, thank you. And we forgot to mention that, put a disclaimer here in the talk that whatever we are sharing here, this is just personal and we not that of our law firm's views. So with that, Laura, over to you. What is your views?
So we've had a lot of administrative rulemaking in the U.S. Patent and Trademark Office. I practice primarily on the trademark side. So that's what I'm going to speak about here. The rise of e-commerce and digital platforms has made the ability to file fraudulent trademark applications much easier. And the U.S. Patent and Trademark Office had an influx of applications, mostly coming in from countries outside the U.S. With fake claims of actual use. And one unique thing about the U.S. system, as compared to nearly every other system in the world, is that you need to have actual use in order to get a trademark registration, unless you have a home country registration for the exact same mark and goods. So that created a lot of incentive for fraudsters who wanted registrations in the U.S. to create specimens of use and make claims of use that are not accurate. And the U.S. PTO has employed a number of measures coming from various directions to try to combat it. One upside is I think it really does help to fight fraud. One downside is it puts an extra burden on legitimate applicants and their counsel, and can increase, unfortunately, the cost and time that it takes to properly file an application and get a registration. And the examples of these kinds of requirements include very strict scrutiny of specimens of use, questions about whether it's a digitally created mock-up or an actual photograph of a product, requirements. This was a fairly new requirement that applicants from outside the U.S. designate U.S. counsel to represent them, as opposed to be able to file pro se without any representation. Audits of claims of use when, because we also have this requirement at the maintenance and renewal stage. And if you have a registration for a long list of goods, it's common now to get an audit where you need to prove actual use in connection with the various goods. If you submit a web page as a specimen, you need to document the exact URL and the date that you access the web page. And that's just one of many different kinds of approaches that the USPTO is taking to fight this fraud.
Great to hear that. And I would also briefly like to talk about those recent changes, what we have seen. And in fact, the Indian government has been on the kind of spree of repealing the draconian laws and bringing in new legislation. So the list is very long, but I'm just going to briefly touch upon few. Of course, our new civil law and criminal law will be enforced in just a couple of months with significant changes. As far as IP is concerned, the major development happened in 2023 when the Tribunal Reforms Act was launched, which repealed the IPAB Intellectual Property Appellate Board, which was a quasi-judicial body to handle IP disputes. Therefore, all the IP disputes cases were transferred to the high courts so we have about 25 high courts in India. Now, all the high courts are supposed to set up a separate IP divisional bench. Now, there are 3 or 4 have already been set up, and the rest to follow. That has been a kind of a good change. Now our disputes are being handled more efficiently, and the decisions are coming much faster. So that was a good change. There have been a lot of new legislation. The Patent Amendment Rule 2024 was just enforced a couple of months ago, which brought in a lot of new changes. That includes. So I'm not sure how many of you practice patent, but there was a very weird rule where if any foreign applicants file patent application in India, and if there were corresponding applications was filed in other countries, you were supposed to keep the Indian Patent Office updated every 3 months, every on and off, and that was a huge burden for everybody. Now with the new amendment, you had to just file twice, once at the time of filing application, and the second at the time of filing a response to the office action. The another amendment happened in the patent law was that there is something called statement of working. So earlier that we were supposed to file a statement every year if we have a granted patent in India, and that was a kind of huge burden. Now we have to file once in 3 years. Besides, we also had a kind of huge jump in case of IP filings. Now, as per the WIPO statistics, India ranked 5th in terms of number of trademarks application filed annually and 6th in the world for patent filings. So that's a huge jump for a country like India, where we were lagging earlier. We also passed a very significant law, Cinematograph Amendment Act 2023. And that happened after almost 40 years, and that was mainly to curb the film piracy. Now the penalty and the imprisonment is pretty serious. Another was that very interesting one. Guidelines was launched for the prevention and regulation of dark patents. When we talk about dark patents, there were certain things, guidelines which were to target practices such as the false urgency, basket sneaking, subscription traps, confirm shaming, forced action, nagging interface. So with this digital era, there were a lot of issues coming in, and then the government went about launching these guidelines, which is definitely going to change the way we use internet, the way we interact, communicate with each other. So this is a kind of very noticeable change here. So with that, we would like to move on to the next topic, and today's main discussion is about the changing landscape of law firms. So we want to focus more on how the law firms globally are working today, and mostly after this pandemic, which has changed the complete the way we worked earlier. To begin with, I would like to probably ask Dilek, while digital transformation has offered significant advantage, but it has also introduced challenges such as cross-border online piracy and infringement. You talked about a few things. So I would like to ask you, how is digital transformation reshaping the IP ecosystem, particularly within IP law firms?
In this topic, I'm a little bit more drastic, I think. I think the digital transformation issue should be already done in 2024. So I think firms who are really not working digitally, who do not have a digital support and own software or a software database for cases, etc., if they are not digital or fully digital, I have to say fully digital, because there is digital and digital. The first digital thing is that you're maybe tracking your files through a software. The second is really if you are using all the tools, because these softwares are like something you have to play with. You have to integrate something, and there are also in Europe there are many softwares to use for IP and law firms. I think the question is, how do you use it? Do you use it and just to use it to work on a file as a team, or do you use it really in your reports, in your daily life? So it does. I think the question is, does the digitalization or the software help you to maximize your services, to optimize everything? I think this is the first thing. And my statement is totally, if there are still firms who are not working digital with a digital archive, with everything digital. So I also myself, so I take my notes for each case very detailed, even if I'm at this stage the single trademark attorney caring about this case or this patent case. I take my notes as if I would die next week and other colleagues have to work on my file. So I think this case is totally clear in my mind. We are totally digital. I can't imagine to work not digital or just half digital. I think IP law firms have to complete the digital transformation until the end of this year. So they will going to be lost in the next years, because artificial intelligence comes now, and this will also be part of our daily working life. So this is my total strict statement in my mind. So.
Sure. Peter, I know you have been teaching copyright law, for a very long time. This question is for you, and Laura as well, to you, if you would want to add something to that. How can we address copyright issues in the digital era, considering the rise of online piracy, these cyber scams, and the ongoing debate about fair use?
Well, the copyright law has always had to respond to technological changes. That's what's driven copyright law right from the days when printing started, when movable type was invented. So there's nothing new for the copyright world in that new technologies are coming along and requiring some sort of reaction, requiring to be brought within the copyright system. It's just the sheer volume of material that we've got to cope with that's a big problem. Fortunately, in the UK, I think we can say we've got legislation which in 1988, when it was enacted, was deliberately made future-proof. So we have a provision dealing with the ownership of copyright in computer-generated works, which I think for years we wondered why it was there. The government was very proud of itself in 1988 that we had the most up-to-date copyright law in the world, but why? What was it going to do? And now suddenly with artificial intelligence we can see a reason for it. We have copyright law which will address this problem of who owns the copyright in something that's created by a computer. The answer is it's the person who set up the computer to create the work. I mean, there's nothing earth-shattering about it. It's not a radical solution, but at least it's there on the statute book. And we also have provisions in the legislation to deal with data mining. That's a more recent amendment. That's been on the statute book probably for about 8 years, I think. My understanding is that the artificial intelligence industries don't think it goes far enough. But of course, copyright owners will have a different view because artificial intelligence machines are voracious consumers of copyright material. And I've had some exposure to this because I'm a member of the Society of Authors, my trade union, and in fact I've been a member of the trade union executive in recent past. And artificial intelligence and the way the machines are trained is a matter of great importance to authors, but also to all kinds of other copyright creators. And we're arguing very much for maintaining a situation where consent is required before copyright works can be used for training AI machines, and for as much transparency as possible about what goes into AI machines and what comes out of them. And these are matters which the law will have to address at some point in the future, because they're not things that have been thought about before. We might have a copyright law which is up to date in some respects, but in other respects, it isn't. You can't legislate until a problem comes along. The copyright law can't lead. It's always got to follow, and I hope that it won't be too long before it follows. But our government's track record on finding time to legislate on copyright law doesn't make me optimistic about that.
Amazing observation. I totally agree with you.
Right. Laura, I'll come to you to get your perspective on that. But Peter, a follow-up question on this, of course, I'm not calling you old, but with your experience of 20, 30 years, what are those issues, what you saw in copyright, the infringement or anything else 30 years ago, 20 years ago, and 10 years ago, and now? Of course, today we're talking about the digital piracy, online infringement. What was the main issue about 20, 30 years ago for copyright?
20 or 30 years ago? Well, in fact, you do me a favor, because my experience goes back even further than that, I'm afraid. I remember when the Copyright Designs and Patents Act 1988 was being debated in Parliament, and one thing that the members of Parliament got very excited about was the prospect that shops would be set up to hire out CDs, which people could borrow overnight and take home and make a digital recording and then take back to the shop the next day. So a CD would only ever sell one copy, and then everybody would make copies from it. They'd hire it out, and it never happened. Partly, perhaps it never happened because the law saw it coming and made sure that it was covered off. But I don't think there was ever any great demand for that anyway. Now, of course, we've moved on such a lot from there, and the fact that streaming has really taken over. I can't relate to all this, to the fact that people now simply stream music and never own collections of CDs or even LPs, although LPs are coming back now, aren't they? It's a different world for me, but and copyright law has had to adapt to all these things, but copyright law adapts better than I do, I think.
Fantastic. Laura, what's your perspective?
All right. So, our on both the copyright and the patent side, although I don't know you've asked specifically about copyright here, I think in the U.S. we're kind of scrambling to figure out who owns what in the when it comes to AI created works. I think the U.S. Copyright Office has come out with directives and then had to sort of or decisions, and then had to sort of backtrack on those decisions to allow for the kind of situation that Peter mentioned, where, it's not AI doing the creation. Well, it is, but it's somebody, a human, who's directing the AI to make. AI isn't just sitting there spitting things out. Are people familiar with the monkey selfie case that we had in this country a few years ago?
Yeah, of course.
Where a monkey grabbed a camera from someone. I don't know if it was actually a monkey or an ape, but people call it the monkey selfie case. Grabbed a camera, took an adorable picture of himself. And then an animal rights organization tried to argue that the monkey owned the copyright in the photo and was unsuccessful. And it kind of kicked around for a while at different levels. And it's, sort of, similar when it comes to AI. The AI can't be a copyright owner. It's not a person. It's going to be the person who directed the AI to make the creation. But I feel like it's made giving advice to clients challenging as we sort of navigate this in stages. It's all happened so fast. And whatever we might advise now might not be the case a month from now. So we're definitely in that tricky age. And I just want to, as long as we're talking about copyright in the digital age, I just want to throw in and something on the flip side, which is that copyright trolls have created a commoditized business out of going after website owners who innocently put up photos they've found online without realizing that they're copyright protected, and are chasing these people for damages, usually in four-figure amounts, high enough to cause pain, too low to hire an attorney to fight it, because you'll end up spending more on the attorney. And just if anybody out there has photos that they didn't take or did not secure the rights to on their websites, please take them down. If you have one takeaway, it's that.
Dilek, you have
Good
something
advice.
to add to?
Maybe my question is in between of Peter and Laura. There was a case, New York Times opened a lawsuit against OpenAI due to the source matter. Do you know this case? What do you think about that in concerning copyright? Because the summary is New York Times said to OpenAI, you are using my sources, my articles, and I'm a paid newspaper and a magazine, and this is the reason why New York Times decided to open a copyright lawsuit against OpenAI. What do you think about this, Laura?
OpenAI is being challenged by the New York Times, by well-known celebrities and comedians, and by Google, all for the similar idea that they're pulling in the information and using it for training. I think under the state of the law, these entities have a cause of action. It may be similar to what Peter was just talking about, how we had CDs and we're trying to legislate around those for a while, and now it's, gotten even, more out of hand than that. It may just have to be an adapt or die situation for these plaintiffs, because once the genie is out of the bottle on this technology, it might be more practical to try to work within it than to try to fight it.
I have another question for Laura. Sorry, Dilek, go ahead.
I don't know if I'll know the answer. Okay.
You mentioned that AI cannot own copyright, but how do you treat the fact that when you log into a AI machine, as Peter calls them, you have this notice that all material that you put into it belongs to the, in this case, OpenAI, let's say.
Right.
So how do you treat these notices? Should I treat them seriously?
Well, that's a
just
good
ignore them?
question, and I think that will get sorted out over time as well. But that's different from saying that AI owns the copyright. That's an entity behind the AI. It's the AI provider that's trying to take the position that they own the copyright, not the AI in the ether itself. So
yeah, it's AI is a capturing concept. It's amazing, and you can't help being captured by the fact that a small person is sitting behind the screen and typing your answer so quickly. It's amazing. I mean, really, it's But
When
on
I
the
first
other hand,
discovered
on the other hand,
ChatGPT, I was amazed. I was having it write
exactly,
songs in the style of Bruce Springsteen and
exactly,
all kinds of fun things
but
like that. I calmed down after a couple of days of that.
right, but
In fact, our next topic is on AI. But before that, Birgit,
Santosh,
you wanted to you wanted to
yeah,
add something to that.
may I just
Please.
present a really fun story about, speaking of generative AI being a ferocious consumer of copyrights. A friend of mine, he prompted into Tell-Aviv, please draw me a picture of Super Mario, which is this plumber figure, which is pretty well known, with the blue pants, cap. So please draw a picture of Super Mario for the birthday of my daughter. And Tell-Aviv said, no, I'm not allowed to draw a picture of Super Mario. This is a trademark. What I can do, I can draw you a picture of a happy plumber in black trousers presenting a birthday cake. So what came out was exactly the figure of Super Mario. So far as being a ferocious consumer of copyrights. Thank you.
I have tried a similar thing. I have tried a similar thing for my daughter, but that was not Super Mario. That was something else, and the result was similar. So okay. I can say whatever I can relate to. Yeah, please.
I have one thing in favor of AI. Maybe you're not aware of, but there is the Israeli Patent Office has various possibilities of search possibilities and search options, and one of the search options is using the facility of an Israeli company called Similari. And Similari is using AI technology to search patents, and it's available to everyone. So there's some good items. So there are good aspects in AI.
Absolutely. The next topic is, of course, the impact of AI on IP. AI is transforming the practice of of IP law, and not only IP law, for all sorts of law, wherein people are using AI to draft legal documents. People are using AI to track the products, and people are using AI for each and everything. A lot of times we see the clients using AI to create their own documents, and they come to us when the matter reaches, to the court. My question is to you, Ron, to start with. How are emerging technologies such as AI altering the practice of IP law? And what innovative tools are IP law firms employing to enhance their services to bring in more efficiency? And I'm not talking about only AI, but other tools which are probably having AI in the background.
Well, I think that AI can be used in an advantageous way to in the IP world. For instance, I think that drafting patents to a certain extent, I would say, is legitimate, is acceptable. You can be assisted by AI. I can think in the same aspect that drawings for a design can be assisted by AI. And the same applies also to a text of a literary work. But then again, you have the question: who is the owner of the rights in this product, the design, the patent? And let's say that you use AI and you represent yourself as the creator. I made the drawings, and should there be a disclosure of the fact that you were assisted by AI? These are important questions that I'm not saying that anybody has answers to them. And I can conclude one thing regarding AI. It's very, very attractive. It's amazing. But bear in mind that we as attorneys, there are two items: responsibility and liability. Important words in our world. And therefore we should be, I think, very careful in using AI.
Peter, what would be your response to Ron's observation? on AI?
I don't draft patent applications, but when I started thinking about the use of AI in that field, and also in other areas of practice as well, I began to realize that there are some massive problems with confidentiality. And obviously it'll be very, very easy to disclose client confidential information by putting it into an AI machine. And because the AI provider does a copyright grab at the same time, that could cause massive problems with the ownership of rights in client documents. But an even worse problem, I would have thought, and perhaps Ron would have some ideas about this, is that if you use an AI machine to help you draft patent claims, then are you immediately putting that in the public domain? Does that then form part of the state of the art, and you destroy the novelty of the patent before you've even written the application?
Peter, here a small observation before I come to other panelists. There are a lot of AI tools for the patent drafting. So when we talk about any open tool or the public tool, like say ChatGPT or anything, this is the public tool. Any information you feed, it's open to all. But there are specific tools, AI backed tools, and they are not public tools. So probably I'm sure they have done some fencing around to ensure that your confidential information is not shared, it remains with you. So that's a private tool. I think there are multiple tools to that. Now, of course, I come to Laura, but Laura, you work with a kind of a large or mid-sized firm, and I'm sure the US and other Western firms are using various AI tools. Do you know if your firm or any firms they are kind of using those AI tools, and whether these tools have brought in some efficiency or helping them move faster?
So we haven't rolled out anything that we're calling an AI tool at my firm. I know that we developed a policy around AI-related practices, which of course one element was what Peter was just talking about, which is confidentiality. Sure, you can use AI to make a first draft of, say, a cease and desist letter, but if you're plugging in the actual facts and I cringe even thinking, the actual parties, then into a tool like ChatGPT, then you're you've broken attorney-client privilege, and you're setting yourself up for ethics violations. I think that I'm not yet aware of those tried and tested tools where we can feel comfortable with the level of security going in to take care of such things. I'm sure they're coming very soon. The other thing that I haven't quite seen yet, the major legal research providers, I don't think are quite there yet with like the natural language kind of search. And even I know I was working on a uniform dispute resolution claim against it. I was drafting a complaint related to domain name, a cyber squatted domain name, and I was on a popular search site thinking, wouldn't it be nice if I could just say, find me all the cases where the squatter did X, and we're just not quite there yet with the legal research, and we're still at the exact term stage. We're getting there, but it's taking its time. So that was a long way of saying that, no, we have not rolled out any major AI solution yet at my firm.
Okay. Birgit, I would like to ask you, today this term AI and machine learning is being abused, if I could say. Every product, every service, we are getting offered, they always mention we have AI. We don't know what kind of AI or machine learning is running behind in those products. I'm sure all of us are getting those vendors' products, day after day. What is your experience? What kind of products these European firms are using in terms of document management, drafting, case management, and IP management systems? Is there any specific tool? I'm going beyond AI and beyond machine learning. Which are the advanced tools?
In Austria, we have software companies like Advocat. In there, they open a mask and you can do all the filings. And then we have some tools and products. One is Law.at for various contracts, which is pretty useful, but it's quite expensive. It's $99 a month in the simplest version. So for a super small firm, it's an add-on, it's this and this and that. So, but I work with Law.at. Other than that, we have search programs. Everybody has a trademark search programs like Core Search and so on. Strictly spoken, that is AI. And I personally use a lot my ChatGPT. So I put on all my online information in my ChatGPT. So I consider that to be super useful, actually.
Right. Dilek, a quick question to you. In today's scenario where all the clients, they want a reduced fee, they want discounted fee, and they are not ready to pay the fee what probably they paid a couple of years ago. And at the same time, we need to increase salary and remuneration of our colleagues. How can we use the technology, the advanced technology, to bring in more efficiency while taking care of clients' requirement and taking care of our colleagues?
What we experienced is that, for example, boosting your services with digitalization is very important, because standardized reports or notifications, notifying about the client about registration decisions. These are things which are really, there's less know-how or need for know-how behind. You can really digitalize such things, which forces, of course, the new generation of IP stuff in the office to be more efficient, to be more talented, to have interest because I believe even if some services are easier in the future and maybe not that expensive that it is today, because it's easy to handle those, IP will never find an end, because now artificial intelligence is a new area for us attorneys. I made, for example, while Birgit was speaking, I asked ChatGPT to write me an article about novelty patents. Okay, it did. And then I asked for sources, and the ChatGPT said, "Oh, I'm a source, and I'm trained with a number of texts." And I said, "No, tell me your sources." And it was so intelligent that it said it was EPO and WIPO and several books and articles written by IP professionals. And I said, "Okay, do you have any copyrights on this?" "No, I do not have any copyrights. However, if you have any more questions, please ask your attorney." So I think this is the future, that everything refers at the end to attorneys and IP attorneys and attorneys who are dealing with copyright. Back to your question, I think some services will be, of course, cheaper because it's easier to handle. However, there will be new services, and there will be new service models like online IP protection. I think this is the most important thing, because internet is going so fast, it's so dynamic. You have to use really tools in order to detect infringements or any unlawful things like copyrights. And
on to the next topic, and which is, of course, the remote work and the global collaboration. Well, until 2020, we never heard and we never thought something like remote working or hybrid working. We never imagined the schools would be shifted completely remotely. The students are going to attend classes through mobile phones, through laptops. Of course, there was something called homeschooling, online classes, but not completely shift. The same thing happened with the companies. We never imagined those companies could work from away, being away. Now, what has changed? What this pandemic or these hard times has taught us, and the technology has helped us to overcome those situations. Now the question here is, how have IP law firm adjusted to remote work environments? And this question is not that how your team is working, whether they are working from home or office, because that becomes very specific questions. But when you are collaborating with a client or your colleague who are a different time zone, how are you collaborating when they are not in office? They are in office or stuff like that. So how has this remote work affected, whether it's for good or bad? Let's start with Peter. I think you have worked with the larger firms, you have worked with the mid-sized firms, and you have a great experience. And now I think you work from home, if I'm not wrong.
Yeah, that's right. I'm working entirely from home, and if I didn't tell you that, you wouldn't know. We can all work from home, and it's entirely seamless now. It's not the same in every walk of life. I think lawyers are in a privileged position, and probably other professionals too. And of course, there are many jobs that you can't do from home. But for the legal profession, the idea of home working is very relevant. I think one of the big problems that you hear about to do with home working is that there's a lack of supervision, that workers are off at home and their managers don't know what they're doing. And very often you also hear the problem that the managers are at home as well, so there's nobody running the business at all. But that's another matter. The great thing for the legal profession, it seems to me, is that law firms have always counted the hours that their employees work. So whether they're working at home or in the office doesn't make a great deal of difference to that. They're still recording the hours. And of course, for the employees, for the lawyers, recording the hours is of paramount importance. So they can be relied on quite well to work from home. It works well for the legal profession and for other professions that charge on an hourly or similar sort of basis, where time recording is crucial. So we've embraced it. I think it's the new normal.
Good to hear that. And before others want to add on to this, I just want to add another angle to this question. People have been talking about, is it good to work from anywhere remotely, whether home, office, or whatever, from the beach. But when it comes to working as a team, where we learn from each other, when we're working together under one roof, there is always, a different angle to it. We are able to discuss immediately, and the learning goes up. And that's why, at least in Indian companies, we thought that will never happen, but they are forcing people to come back to office all 5 days, 6 days a week. So what is your take when you respond to the previous question? Please consider this one as well. Ron, over to you.
I think it's what you mentioned. It's the end of brainstorming. Brainstorming is someone you have to go to next room and consult with someone who works with you. And I know the difference. I know both situations, but regarding the Peter's remark that hours recording is the most important, it is the same when you work from home. Well, from what I know, cannot agree. You, Santosh and Laura, can say, do you really think that the hours recording are the same when you work from home and not? I would say I would make this gesture, if you know what I mean. It's not. You can have a nap at home and pretend you are working. You cannot do that in the office. I rest my case. Sorry.
Sure. Birgit, you want to add?
Well, as to the end of brainstorming, I don't totally agree with you, Ron. I mean, one thing is you can brainstorm with ChatGPT, which is actually quite fun. And I put I put the questions or topics into ChatGPT, and when the output was actually quite good. But to be
There's
serious,
no brain there. Where's the brain?
Giant brain there.
maybe it's smarter than
well, just as one example that I'm very aware of when I draft privacy notices for clients, the privacy notices have to be so long and detailed these days that they are not doing their job because nobody is ever going to read them. If they're going to be effective, they need to be much shorter. But that's not the way the data protection law is going. It's going in the direction of becoming more complicated and more incomprehensible.
Sure. Well, moving on to the next topic, and considering this digitization and the use of various technology and the platform, the IP enforcement is becoming a big challenge, and mainly so for cross-border transaction. What are those ways? What are those opportunities here? So, Laura, if I could come to you and ask you, how do you address these cross-border enforcement, and how the firms in the United States are going about it, enforcing the IP in terms of the digital era?
Yeah, I mean, it's a challenge, and it needs to be approached through various fronts. Obviously, takedown notices can be effective. The registrars and the platform providers have an obligation under our laws to comply with certain takedowns, and that's one way to deal with it. Sometimes, particularly if it's outside the U.S., the takedown isn't effective, and you have to go to something like a UDRP, a domain name dispute filing, and that will obligate the registrars to comply. It can be costly when it happens repeatedly.
Sure. Ron, coming to you on the similar topics, in case of the commercial disputes, or the contract disputes, how do we use those ADR, alternate dispute resolution, to resolve these ones, which would be faster and probably more effective? How has Israel been using this ADR?
Well, first of all, I agree with Laura, the use of UDRP. This is an ADR, a very, very efficient, short, online. This is, look how successful is the so-called Arbitration and Mediation Center of WIPO, but this is really a UDRP center, and it's doing a great job. They charge rather, as opposed to most Swiss entities, they charge reasonable amounts from the users, and have a great success. ADR must be in Israel. I feel it should be, and it is becoming very popular. I started with this issue. We have a shortage of judges, and there is hardly any judges that are familiar with IP laws. If you are concentrating IP, ADR is should be and is, I think, the preferred path to resolving disputes.
Is it mandatory to go to mediation ADR?
Well, the civil procedure regulations have a clause that says you have to go, but you have to go for a single meeting, which is very cheap, and then during this meeting you explore the possibility, if you want to pursue the mediation or arbitration, off you go back to court. In many cases, I think that in these compulsory obligatory mediation, well, maybe 50% or more, are determined when they start the process to go back to court, which is not always right. But I have encountered cases where you get to this mandatory mediation meeting, and the parties change their mind, say, why should we go to court? If the mediator, which is an important job, does a good job, It's they may they may resolve the dispute, and the courts are alleviated. I mean, the
In
situation
India,
is very difficult.
in India, what we follow is a litigation, mediation, litigation. So the commercial disputes, and I would like to highlight those IP cases where it's mandatory once you file a suit to go for arbitration, mediation. But there is an exception that if you if you pray for interim injunction, you don't have to opt for mediation. So in all the IP cases, there is always interim injunction, and that kind of
Right.
exclude mediation, and that's what people would go for. They just want litigation, they want ex parte, which they would not get through mediation.
I think
Birgit,
that if the arbitration agreement is phrased correctly, you may even nowadays solve this problem, which is a classical problem of injunctions. Seizures, not really, but injunctions may be solved with an appropriate arbitration clause.
Sure, get it. Of course, coming to the second last questions, and quickly we would like to get your brief responses. In today's world, where so many new technologies are coming in the market, and we have no option or choice but to learn and use, adopt, and probably get the better of it. Wanted to understand, from your experience in your firm and in your jurisdiction, how are law firms facilitating adoption of these newer technologies, and what strategies is your law firm implementing to accomplish that? If your law firm is moving towards adoption of new technologies, new tools, and how are you upskilling the associates or your colleagues? Laura, do you want to start with?
Yeah, I mean, I feel like, and I don't know if it's unique to the US or if it happens in other countries too, that because law firms tend to be rather risk averse, it can take a while for these tools to get rolled out. And as I mentioned earlier, we're not there yet with any kind of major AI driven platform. We've just worked hard on policies to guide people in how to use AI safely and ethically. I'll probably have a different answer about a year from now. And maybe we should convene next World IP Day to do an updated version of this program.
Anybody would like to add to that?
I think
Right.
just one question to this. We have to adapt, but we have to be careful, because adapting too much is also, you maybe know the lawsuit against CPA Global, where a patent an inventor opened a lawsuit because they failed the due date for PCT. And it was a totally human mistake of creating the first due date. And it's hard to fail a PCT due date because there are many stages. However, I think we are forced to use it, because I remember back before 15 years we used Excel lists, for some files to track, and this was really I can't imagine to use them today. This means for me, we have to use it very efficiently, but we have to be careful. Totally relying on things, on software or some technical things is wrong, including AI. However, our own software as well. When we enter a due date, there are really double eyes to look into the due date, because you can fail. You can fail with the month, you can fail with the day. And then you can use all technological tools, and you cannot prevent this mistake. So we do not have to rely fully. Be careful, just
Completely. I'm with you on this. Now, on to the last topic, of this discussion, is that the future trend. Where do we see the law from 10 years now or 20 years from now? And I would like to start with the Peter, because again, going back to the previous question, where were these law firms, IP firms 20, 30 years ago, and how they have evolved in terms of technology, and where do you see these law firms from 10, 20 years now in terms of usage of technology, how fast and how far we can go. And I would like to get a quick response from everybody on this.
Well, I see over the next 10 years the likelihood that law firms, not just in intellectual property, but in all areas of law, will be becoming looser organizations, taking advantage of the technology that allows distributed working, and moving away from the partnership model, which so many younger people find just too much, too dominating, too difficult to work within, and people want to have a better work-life balance, and the technology is there to deliver it for them. So law firms, I think, are going to have to embrace that and become looser sorts of organizations, and that's I think going to be what we will see happening over the next 10 years.
Get your point. Laura?
My answer is similar to Peter's. So one thing we have in the U.S. is, we're 50 states and a few territories, each with their own bar requirements. I think requirements whether you have to have an actual office to practice there. And I think those have already started to loosen up over the pandemic time, and will just continue to be looser. I think you'll still have to get admitted in a jurisdiction in order to practice in that court, but I think there won't be the kinds of rules around, say, living in one state and being admitted to and practicing law in a different state. I just don't think that's sustainable anymore.
So you are saying they're going to be probably virtual courts and people, appearing from their remote areas, and also virtual office, and it will give you a feeling that everybody is sitting together working, and you don't feel that you are away.
I don't think we'll be quite at virtual courts in 10 years. I mean, obviously we did it during the pandemic to the extent necessary, but I think court will continue to be in person, but I think law firms will get increasingly virtual with a relaxing of rules around. We also have taxation rules. If you live in a state and you practice in another state, I think all of those rules are going to have to be relaxed to accommodate today's working model.
Sure. Ron, what's your take?
Well, it's very difficult to predict. Israel is a place that you don't know what happens tomorrow, but really, I feel from my experience in recent years that law firms are getting larger and larger. They are, collecting existing firms, and they become like, we didn't have, like 10 years ago, we had the largest firm was like maybe 50 lawyers. Now we have firms of 300, 400, 500 lawyers. And I think this is a tendency. You merge or into a larger firm, and I think this is in a sense this will continue to happen here, and otherwise, well, the problems that Laura or the solutions that Laura is speaking of does not exist. We are a small state. There's no like states. We have one bar. We have one law, and so it's the problem is very unique for the US, but maybe in India it's relevant.
It's different. Dilek?
I totally agree to all comments. I think I will just comment this in terms of our profession. We are talking today about we will lose our job, or will AI replace us. I think the thing is new. There will be one point where we will forget everything, and our softwares will be totally AI and do all the uninteresting things. And we have to develop ourselves more and more, like before 50 years, where lawyers were really studying all the texts, all the laws, all the regulations. And I think we will be forced to learn new things. Just to underline my thesis, the government of Singapore announced to all professionals in all branches and activity fields to develop their profession and learn new things due to the new era of AI and technology transfer, etc., etc. The government of Singapore sees it coming that we have to develop ourselves in a different way, and we are forced to do so, I think.
Birgit, concluding remarks from you.
Well, 10 years is really long time, and I don't have the glass ball with me, but I mean, if you consider how fast things changed within the last 10 years, so the next 10 years are gonna be really fast, but there will be more technology, even more, and we have to embrace technology. No, AI is not going to replace us because there will be more problems and more regulation, and already within the European Union, there are so many new regulations every day. There is the Data Act, there is the AI Act, so every day, so many regulations. Thank you, European Union. So we have so much work. And there will be less young people, at least in Europe. So there will be a lot of people 50 and older, so being retired at 68, whatever, but not many young people. So we have a lack of talented young people. So I think we are gonna work and have a lot of work. What I see is a little competition from tech firms offering legal advice, like a generator. You can do your terms or your contract yourself, or you can file your lawsuit yourself. And already we have a Supreme Court decision in Austria saying that legal advice, contract drafting, not only representing clients before court and authorities, but legal advice and drafting, that is a lawyer's thing. So that is, if a non-attorney is offering legal advice, it's an unauthorized practice of law. So thank you. Meaning that because now there are a lot of tech firms, they offer trademark applications and everything. So we have a Supreme Court decision saying, yes, attorneys can use AI, but attorneys can use AI because they are liable and they have to think about it and they use it as a tool and a source. But it's not allowed for tech firms to offer legal advice via AI if they're not attorney at laws.
I think with that, let's conclude this. So thank you so much. It has been such an interesting discussion. Thank you once again to all the participants, panelists.
Thank you.